Greetings to all. My name is Milmantas. I'm a regulated Canadian immigration consultant located in Toronto. This time, I would like to share with you a recent case wherein the foreign national applied for a work permit, which was refused, and then subsequently his judicial review was dismissed as well. The applicant was found guilty for misrepresentation under paragraph 40.1.a of the Immigration and Refugee Protection Act, which means that the applicant is inadmissible to Canada for a period of 5 years. I hope that by sharing this case, I will help you to prevent from making such a mistake, and let's briefly look at the case. Every application has a number of declaration questions, and the question was, have you ever committed an offense? Have you ever been arrested for? Have you ever been charged with or convicted of any criminal offense in any country or territory? Means when you break down this one question, there are several questions in that one question, and which requires the answer yes or no. This is simply non-negotiable. The answer is yes or no. So let's look at the case. The judgment and reasons in this case is knowingly is emphasized, my emphasis added, knowingly omitted their previous criminal history in order to obtain a work permit in Canada. And further, in this next page, what happened here? The applicant submitted an application. He did not include a police clearance certificate. Most likely it was not required. But immigration officer decided to ask him to provide a police clearance certificate during the review of the application. And that is when the immigration officer found that there were 4 prior criminal convictions. And the applicant was stating that this is an innocent mistake that he forgot. Innocent mistake. Then his criminal lawyer from Hong Kong was arguing that the convictions were spent. The applicant shouldn't declared it in his application. So it is according to the Hong Kong law, the application was spent. But the applicant was applying for a work permit to Canada, and Canada has different requirements, different laws. And we are going back to basics that every applicant has to be truthful in the application and answer all the questions truthfully. The decision maker concluded that the misrepresentation was deliberate based on a balance of probabilities. I am not satisfied that applicant knowingly omitted their previous criminal history in order to obtain a work permit to Canada. I invite you to read the entire case because it is a very interesting case. It is a very interesting read. And finally, if you need help with your application regarding criminality, or you need any assistance with your immigration application, please complete our online questionnaire to establish your eligibility under any of the immigration programs that might be applicable to you. Thanks for watching, and I hope you found this presentation informative. I kindly invite you to like, to subscribe, to share the channel in order to receive some immigration tips, which I gained over more than 20 years of experience. I wish you luck.